Now the point is uh, who are entitled to maintenance according to the Muslim personal law, as well as of course section 125 of the old CRPC, and now uh, new section 144 1 of the भारतीय नागरिक सुरक्षा संहिता 2023 makes the provision for the maintenance of the following persons. They are number one, wife, children, and parents. Here I would like to clarify that since I am dealing here with the maintenance under Muslim personal law, therefore, first of all, I would like to clarify that Muslim personal law is based on the customary laws prevalent before the advent of the Islam, and therefore it is the oldest part of the customary law, oldest law on maintenance. Because before the advent of the Islam, after the marriage, to escape the responsibility or liability of the maintenance, the husband would frequently divorce his wife, and thereby they were rendered as destitute and vagrant, helpless, and totally dependent on the charity of the society. This evil practice was noticed by the Islam itself when it started the social reform. So it effected reform not only in the institution of the marriage, but at the same time it made a successful attempt to effect the necessary reform in the rights and obligation stemming out of the union of the marriage. And first and foremost reform was that it made all the spousal rights and obligation flowing from the contract of the marriage in the nature of the civil right, enforceable in the event of breach of either of them in a court of competent jurisdiction. Therefore, Muslim law, while conferring the status of wife on a woman, also allowed to maintenance and provided that if the husband neglects or fails to maintain his wife, the wife will be entitled to knock the door of the court for the recovery of the maintenance of for the recovery of her maintenance from the husband, in the absence of the husband, from the property left behind by the husband. Therefore, basically the right to maintenance was made available by the Muslim law to three classes of the person. First and foremost class of the person entitled to maintenance, to the provision of the maintenance, is wife. Wife is a class. So this class of the person, that is the wife class, is first and foremost entitled to the provision of the maintenance enunciated by the Muslim personal law. The next to her in order entitled for the maintenance are children. And the third and the most important segment entitled for the maintenance provision is parents class. Now almost all the civilized nations, they are enacting the laws for the protection of the interest of the parents in their last age, when they are in the last age, to ensure that they are not neglected, they are not leading a destitute and vagrant life, dependent on the charity of the society. Now almost all the laws, all the civilized nations have enacted the laws providing protection to the parents in terms of their maintenance and care. In India also, a special law has been enacted in 2007, and there are various provisions providing for the maintenance, support, care of the old age parents. So now the modern laws, what modern laws have started thinking in contemporary time, Muslim law thought and took the note of all these persons well before the time, well before, and many hundred years before, or that is at the starting point of the mission of social reform undertaken by the Islamic legal system. Now here, therefore, I would like to discuss first of all maintenance right of a Muslim wife. It has already been pointed out that one of the matrimonial rights of the Muslim wife is maintenance that stems out of the union of marriage, which makes her entitled to be maintained on a reasonable scale by her husband so long as relationships subsist and continue. It is the bounded duty of the husband. It is the bounded duty of the husband to maintain his wife during the continuance of her marriage. Husband is bound to maintain his wife during the continuance of marriage, regardless of her physical and financial condition. Thus, he has to maintain his wife even he is ill or undergoing imprisonment, or even when he is destitute while the wife is rich. It also become due even when the intimacy is not possible with the wife due to her old age or her physical defects. Now, in other words, it may be submitted that maintenance right of the wife stemming out of the union of the marriage is absolute in nature, and she is entitled to receive it from her husband under all the circumstances, even when the husband is destitute while a wife is wealthy. But in order to be entitled to maintenance, the wife must be faithful and must faithfully perform the obligation devolving upon her by her marriage contract. Therefore, a Muslim wife shall be entitled to be maintained by her husband when she has been lawfully married to him. If the marriage is batil or void, then she shall not be entitled to receive the maintenance from her husband. There is no conflict of the opinion among the jurists of Muslim law so far as the maintenance claim of the wife during the subsistence of marriage is concerned. All are in agreement that so long as marriage subsists, continue, husband should maintain his wife as part of his obligation imposed by law on him. Now then, what is the scope of maintenance on the dissolution of marriage? Because it must be crystal clear to the audience that after the marriage, wife becomes entitled to the maintenance and husband is under obligation to make the provision for maintenance of his wife on a reasonable scale out of his available economic or financial resources. It must also be kept in the mind that financial status of the wife is irrelevant to the claim of the maintenance. At the same time, destitution of the husband is also irrelevant so far as the obligation of the husband to pay the maintenance is concerned. Further, since the maintenance is right arising from the contract of the marriage, therefore, as soon as the union of the marriage comes into existence, right of the maintenance arises. Not only arise, but it continues so long as relationship subsists and continue, means the marriage union of the marriage subsists and continue and parties remain as a husband and wife. During the continuance of the marriage, becomes the exclusive right of the wife to which she is always entitled to receive from her husband, provided marriage of the claimant with the husband in question was valid, lawful, and wife is performing all the obligation arising out of the marriage devolving upon her during the continuance of the marriage. Then she will be entitled to the maintenance throughout the marriage or during the continuance of the marriage. But the point arises, what will be the scope of the maintenance or right to maintenance of the wife when there is a dissolution of marriage? Dissolution may be effected by the husband or may be effected by the wife, as the case may be. Anyhow, if there is a dissolution of marriage, then what will be the nature and scope of the right to maintenance of the wife? It may be clarified here that when the husband pronounces divorce upon his wife and marriage is dissolved, the union is finally dissolved on the expiry of period of iddat. I have already explained this point that on the pronouncement of divorce by the husband, marriage does not dissolve instantly. Rather, after the pronouncement of divorce by the husband, wife is left for the waiting period known as iddat. and during this waiting period, a relationship are only suspended, not finally repudiated or dissolved. And this during this period, waiting period, only the relationship is suspended. However, relationship can be revived by revoking the divorce, and this opportunity is made available to the parties, that is to the husband and wife, in the event of the divorce until the expiry of the period of the iddat. And the period of the iddat is well defined, that it is 3 months of or 3 menstrual courses, or it may extend to the delivery of the child in case the wife is pregnant at the time of divorce. Anyhow, on the expiry of the waiting period after the divorce, marriage finally comes to an end, and that waiting period is as a general rule 3 months or 3 menstrual courses. That no period is known as iddat. Since during the iddat period, the relationship or marriage relationship arising out of the marriage are only suspended, not terminated. Therefore, during this period, the right to maintenance does not come to end. Rather, this right is still subsist and continue. And therefore, if the divorce has been pronounced by the husband to his wife, and the wife is observing the period of the iddat, then during the whole period of the iddat, the wife will be entitled to be maintained by her husband in the same way and in the same style as she was being maintained immediately before the pronouncement of the divorce. Therefore, during the iddat period, marriage is deemed to subsist, continue with all incidental rights and obligations, including the right to maintenance. And therefore, during this period, even after the pronouncement of the divorce by the husband, the wife will be entitled to be maintained by her husband in the same way as she was being maintained immediately before the pronouncement of divorce, maybe in the ahsan form or hasan form or in any other way. During the period of the iddat, wife is entitled to be maintained by her husband irrespective of the fact whether the divorce given is irrevocable or irrevocable. But on the expiry of the period of iddat, marriage according to the Muslim law ceases to exist with all consequential spousal rights and obligations according to the classical Muslim law. When marriage comes to end, all the incidental rights and obligations arising from the union of the marriage, they also cease to exist. Marriage ceases to exist on the expiry of the period of the iddat in the event of divorce or dissolution of the marriage. And therefore, consequent upon the final dissolution, all the rights and incidental rights and obligations arising from the contract of the marriage, they also cease to exist and operate. Therefore, according to the classical Muslim law, a woman who has been given divorce in either form by her husband will be entitled after the divorce to the maintenance from her husband only during the period of the iddat, and on the expiry of the period of the iddat, her right to maintenance will cease to exist and claim of maintenance will come to end with the end of marriage, which comes to end on the expiry of the period of the. Therefore, legal analogy is drawn that on completion of the iddat period, marriage ceases to continue. Therefore, right to maintenance of the wife also ceases to exist after the expiry of period of the iddat according to the classical Muslim law of Muslim law. This has been the legal position of maintenance of a Muslim wife, including the divorcee, until the decision of Supreme Court of India in Muhammad Ahmad Khan versus Shah Banu Begum, followed by passing of the Muslim Women Protection of Rights and Divorce Act 1986. And therefore, now in my next lecture, I will discuss the scope of the maintenance right of a Muslim wife after the dissolution of her marriage under the CRPC, Bharatiya Nyaya Suraksha Sanhita, with reference to section 144, as well as Muslim Women Protection of Rights and Divorce Act 1986. Means, what will be the nature, scope and extent of maintenance right of a divorcee under section 144 of the new Sanhita, new code, read with section 3 subclass 1 especially of the Muslim Women Protection of Rights and Divorce Act, because there has been conflicting situation on the scope of maintenance right of a Muslim divorcee after the expiry of the period of the iddat. Muslim law is of the view, has been of the view that right to maintenance cease to exist on the expiry of the period of iddat, and thereafter wife is not entitled to maintenance. But definition of the wife under section 125 subclass B of the CRPC, old CRPC, now under section 144 subclass B, wife is defined. Who can be treated as a wife for the purpose of according the maintenance right to a woman. So now there has been a conflicting situation so far as the definition of the wife under Muslim law is concerned and definition of the wife under section 125 subclass 1B was concerned. Now under section 144 1B is concerned. So the definition or meaning of the extended meaning of the or wider meaning of the term wife basically has given rise to the conflicting judgment on the scope of the maintenance of a Muslim divorcee, particularly in India. And one of the important decision in this context in India has been the decision of Supreme Court in Muhammad Ahmad Khan versus Shah Banu, 1985. In this case, whereas before this case also, there was the point was this: what is the scope of the maintenance right of a Muslim divorcee? But finally, the matter came for consideration in a reference case by the Supreme Court of India as to what extent a Muslim divorcee or a Muslim wife on the dissolution of the marriage, to what extent she will be entitled to be maintained by her husband, whether the right to maintenance will end with the end of the expiry of with the end of the iddat period, or it will go even beyond the iddat period. What is the position under Muslim law and what is the position under section 145 44 sub class 1b of the Bharatiya Nyaya Suraksha Sanhita, and then how what legal development has taken place later on pursuant to the decision of the Supreme Court in Shahbanu case on the scope of the maintenance right of a Muslim divorcee or women who has been given the divorce revocably in any form by her husband. Well, respected audience, I have already discussed wide my previous lectures that a Muslim wife is entitled to the maintenance from her husband throughout the continuance of marriage. So, now today I would like to discuss that in case there is a dissolution of marriage by divorce, then uh, to what extent after the dissolution of marriage by divorce, the divorcee wife will be entitled to maintenance from her former husband. I have already told that under Muslim personal law, a husband is bound to maintain so long as marriage subsists and continue. And wife is faithful to him. But after divorce, husband duty to maintain his divorced wife extend only up to the period of iddat. It means that during the subsistence of the marriage, husband is bound to provide on a reasonable scale maintenance to his wife, irrespective of her financial status so far as the Muslim law is concerned. The only condition to claim the maintenance during the during the subsistence of the marriage is that wife should remain faithful to her husband, and the union of the marriage should have been a valid, not batil or void. After divorce, the liability to maintain the wife is, according to the Muslim personal law, is limited to the extent of period of iddat. That is 3 months or 3 menstrual courses, as the case may be in the event of divorce. On the expiry of the period of iddat, according to Muslim personal law, husband's liability to provide maintenance to his wife ceases to exist, and it comes to end, and thereafter divorcee, according to the Muslim personal law, may not be entitled or to be maintained by her husband, and liability will shift upon other members of the family, maybe the parents or any other relative entitled to succeed her property after her death. This is the position of maintenance of a Muslim wife under her respective personal law, that is under the Muslim law. Because the right to maintenance according to the Muslim personal law is directly connected to the subsistence of the union of the marriage. So long as relationship subsist, union continue, right to maintenance will also continue, and the husband will be bound to make the necessary arrangement for the payment of maintenance to his wife, whether she is able to maintain herself out of her own resources or unable to maintain herself out of her own resources. This is not condition precedent, means of the wife is not a condition precedent to the maintenance. What is condition precedent to the maintenance of the wife is existence of the valid union between the wife and her husband from whom the maintenance is due. There is agreement of all the schools of Sunni law on this point, that the liability of the maintenance is coterminous with the union of the marriage, as since the union of the marriage finally terminates on the expiry of the period of iddat, therefore the liability of the maintenance arising out of the union of the marriage will also cease to exist, or will co-terminate with the final termination of the union of the marriage. Gentlemen, before 1973, under section 488 of the old CRPC, the Muslim wives were entitled to claim maintenance irrespective of her personal law. Means that before 1973, there was CRPC, and under the scheme of the CRPC there was provision for the maintenance made under section 488 of the CRPC. During the continuance of the marriage and on divorce, she was entitled to be maintained, unlike Muslim law, up to the period of the iddat. Because as a result of such provision, in many cases, in order to defeat the purpose of section 488, husband would divorce his wife and thereby used to escape from the liability of maintenance under section 488 of the old CRPC. Meaning thereby that position under personal law I have already clarified. Under the statutory law before 1973, there was provision section 488, and section 408, under section 488 maintenance liability was enunciated, was created. Means a wife, irrespective of her relation, was entitled to claim the maintenance either under personal law or under section 488 of the CRPC. But unlike Muslim personal law, under section 488 of the CRPC also the maintenance was limited to the extent of period of the iddat in the event of the dissolution of marriage by the husband. Therefore, as and when any wife was neglected or refused the maintenance by her husband, and feeling aggrieved from the conduct of the husband, she filed a petition or application for the maintenance under section 488 of the CRPC. In order to defeat or deprive the wife of the maintenance, immediately he would divorce her, and after giving the divorce, she was required to observe the period of the iddat, and during the period of the iddat, husband would pay the maintenance, and on the expiry of the period of the iddat, again the wife would be rendered maintenanceless, means her right of maintenance will cease to exist. So, in this way, almost the same was position under section 488 so far as the maintenance of the wife was concerned, as was under section 4 under Muslim personal law. So, meaning thereby that in spirit, before 1978-73, position of maintenance, statutory position of the maintenance under section 488 and the position of the maintenance under Muslim personal law almost in spirit was one and same, that under personal law, on the expiry in the event of divorce, only up to the iddat she was entitled to be maintained. And similarly, if there was a petition for maintenance under section 488, then again the husband would divorce, and in case of the divorce on the expiry of the period of the iddat, the application will become infructuous, and again the wife will be deprived of the right to maintenance, means beyond the period of the iddat, even under section 488, she was not entitled to be maintained by her husband. And therefore, the divorce was a escape route under section 488 for the liability of the maintenance, because section 488 of the old CRPC required the husband to pay the maintenance to his wife during the subsistence of the marriage, and in case of the divorce, the liability was limited to the period of the iddat. And therefore, when any wife moved an application for maintenance against the husband under section 488 before 1973, to avoid the liability, immediately he will pronounce the divorce upon the wife, and wife will be required to observe the iddat, and during the iddat she would be paid the maintenance, but again on the expiry of the period of the iddat, liability will cease to. And in this way, almost both provision of 488 and provision under Muslim law relating to the maintenance of Muslim wife was one and same. Only difference was that maintenance under Muslim personal law was uncodified, and under section 488 it was it was codified. This was the only difference. Otherwise, scope was one and same under the statutory law and personal law up to 1973.